We've all got that dream renovation project, right? A new deck, a bigger kitchen. But what happens when that dream runs smack into the brick wall of a homeowners association? Well, today we're diving into one homeowner's plan for a new garage that just completely spiraled into a 2-year legal war.
It all started out so simple. A plan for more space, a way to make his house better. But it ended up in front of an administrative law judge. We're talking lawyers, sworn testimony, the whole shebang.
So, you gotta ask, right? How on earth does a simple disagreement over a roof design escalate all the way to a courtroom? What are the rules that even govern this stuff? And maybe most importantly, what was the one key detail that made the judge decide against the homeowner? Let's dig in.
Okay, so our story starts with a homeowner named Mark Archer. All he wanted to do was expand his garage. Sounds simple enough, but as you're about to see, the road to getting that approved was, well, anything but.
And you can see how fast things went south. September 2017, Mr. Archer turns in his plans. A month later, in October, he gets preliminary approval. Everything's looking good. But then, bam, just 1 month after that, everything hits a wall. The HOA denies final approval. Fast forward a year and a half, and this isn't just a disagreement anymore, it's a full-blown lawsuit. So what was the big holdup? What was the one detail so important that it completely derailed this project and sent both sides running to their lawyers? Believe it or not, it all came down to the roof. At its heart, this was a clash of two totally different visions. On one side, you had Mr. Archer, who wanted this cool, modern flat roof for his new addition. But on the other side, the HOA was pointing to the community rules, saying, nope, the style around here is pitched roofs, the sloped kind. Two completely clashing ideas for the very same spot. And this brings us to the single most important number in this entire case. 9 feet. 9 feet. That was the height of the wall right next to where the garage was supposed to go, and it would become the literal line in the sand for this whole dispute. So here's the deal. Mr. Archer's flat roof design was going to be taller than that 9-foot wall. The HOA's argument was that this would make it stick out, making it visible to the neighbors and messing with the look of the community. But, and this is a huge detail, they didn't just say no. They actually offered a compromise. They said, hey, you can have your flat roof, but you have to keep it below the 9-foot wall so no one can see it. Mr. Archer said no to that deal, and that right there is when this whole thing really headed for court. See, when a fight like this gets in front of a judge, it doesn't really matter who has better taste in architecture. All that matters is what's written down black and white in the official documents. And for anybody who lives in an HOA, this is the Bible. The CC&Rs. These things aren't just, a friendly set of guidelines. No way. They are a legally binding contract that you sign on to the moment you buy your home. It's the document that gives the HOA its power, but it also means they have to play by their own rules too. And boom, here it is. This is the core of the HOA's whole argument, straight out of Section 4.4 of their rules. The key phrase, it is intended that pitched roofs predominate. That one little sentence was the foundation for their entire case. Now, this next part was just as critical, because it's where they legally defined the word visible. And this is where that 9-foot wall comes roaring back. The HOA used this rule to back up their compromise offer. They were basically saying, look, if your flat roof stays below the wall, then according to our contract, it's technically not visible, so we can approve it. Okay, so the rules are on the table, the battle lines are drawn, and the stage is set for the hearing. You've got Mr. Archer on one side and the HOA board on the other, both ready to tell the judge their side of the story. So Mr. Archer makes his case. He argues his plan looks great with his own house and that the HOA is being totally inconsistent. He even points out other little rule violations around the neighborhood. But the HOA had an answer for everything. They came back saying the issue wasn't the house, it was the garage. A flat roof addition wouldn't look right next to the existing pitched roof garage. And they just kept hammering home their two main points. Our rules prefer pitched roofs, and we offered you a reasonable compromise based on those exact same rules. So you've got two different arguments, and you can kind of see where both sides are coming from. So how does a judge break the tie? Well, it all comes down to the legal standard, and who brought the better evidence. The standard here is something called preponderance of the evidence. Now, this isn't like a criminal trial where you need to prove something beyond a reasonable doubt. It just means whichever side's story is more convincing, even if it's just by a tiny bit, like 51 to 49, that's who wins. And the really crucial part, the burden of proof was on Mr. Archer. He was the one who had to convince the judge that the HOA messed up. So the judge's thinking was actually pretty straightforward. First, the CC&Rs are a contract, period.
Both sides have to follow it. Second, that contract is clear. It says pitched roofs are the preferred style. Third, because the HOA based their decision on that specific rule and even offered a compromise based on another rule, their decision was legally reasonable. It wasn't just some random arbitrary call. And that led to the final step. Mr. Archer just didn't bring enough evidence to prove that the HOA had acted unreasonably.
And with that, the case was closed. The judge sided with the HOA. Mr. Archer's petition was dismissed. The flat-roofed garage he had dreamed of was officially not going to happen. So this one case out of Arizona actually gives us a really powerful and universal lesson for pretty much any homeowner who lives under an HOA. So, what's the big takeaway from all this? It's that those super thick, boring-looking documents you got when you buy your house, they really, really matter. They are not suggestions. They are a contract. And in any fight, the side that can point to the specific words in that contract is almost always going to win. So it all leaves us with one final, very practical question. Whether you're thinking about a new paint job, a fence, or a whole garage addition, the first step isn't calling the contractor. It's digging out that rulebook, because knowing what it says before you start could save you a world of trouble.